Darcy and Myriad genetics. So who are our actors? Ms. Darcy is a breast cancer survivor. Myriad Genetics is a molecular diagnostic company. Myriad identified that mutations in a gene known as the BRCA1 gene predisposed women to an increased likelihood of breast and ovarian cancer. Myriad patented its discovery in an application covering 30 claims. The first 3 claims were over nucleic acid sequences containing the mutations. The remaining 27 were to applications of that discovery. It is important to recognise that claims 4 to 30 are clearly distinguishable from claims 1 to 3. Claims 1 to 3, despite concerning mutations from the norm, were still to naturally occurring material. Claims 4 to 30 went further. For example, claim 4 was to a nucleic acid probe that might involve attaching a fluorescent or radioactive label to pieces of nucleic acid. What did Ms. Darcy argue? Ms. Darcy argued that isolated nucleic acids, as described in claims 1 to 3 of the Myriad patent, were not materially different to cellular nucleic acid, and that naturally occurring DNA and RNA, even in isolated form, are products of nature that could not form the basis of a valid patent. Myriad, on the other hand, argued that the claim was to a product which was a chemical compound which has no counterpart in nature. In particular, covalent bonds were broken in isolating the nucleic acids, pieces of DNA known as introns were removed, and once isolated, the DNA could not function to produce proteins as it would in a cell. So what did the court say? The High Court unanimously held that claims 1 to 3 must fail. 3 judgments were delivered, but a number of themes ran throughout. Justices Gagel and Nettle were concerned that claims could not properly be characterised as being new or an invention at all. Chief Justice French and Justices Kiefel, Bell and Keane framed this another way by interpreting the claim as being a claim to information and holding that information was not patentable. Justice Gordon characterised the subject matter as a product, but that an attempt was being made to delineate the boundaries of the product through relation to existing facts. Her Honour stated that a fact is not a matter of manufacture within the meaning of Section 6 of the Statute of Monopolies. Secondly, the High Court noted that the claims were merely the end result of an already well-known process of DNA extraction. Related to this was a concern that a researcher might inadvertently infringe the patent if, through the use of the well-known extraction techniques, they happen to extract naturally occurring segments of DNA carrying Myriad's mutations. Justices Gagler and Nettle referred to this possibility as the antithesis of a man-made artificial state of affairs. The significance of the decision really depends on who's asking. For patent attorneys, the decision means that genetic material, generally speaking, will not be patentable. With this noted, applications of genetic discovery, such as the content of claims 4 to 30, will remain proper inventions capable of patent protection. For IP lawyers, the decision means that caution needs to be applied when interpreting previously held tests relating to patentable subject matter. In particular, the test in NRDC that a manner of manufacture result in an artificially created state of affairs of economic significance is overly simplistic. For scientists, the decision means that they can legitimately conduct research that involves isolation of mutated BRCA1 nucleic acid and potentially develop new products, so long as the products don't infringe any of the other 27 of Myriad's claims. Unfortunately, the decision was late coming and the patent expired in 2015 anyway. For the public, the decision is likely to reverse any chilling effect that Myriad's patents had on breast cancer research and hence widen the scope of services available to patients. In particular, secondary or confirmatory testing will become available. There will be a lifting of the monopoly and a corresponding decrease in the cost of genetic testing relating to BRCA1. And finally, there would be decreased mortality and morbidity rates.